Good morning. My name is Tracy Canales. I'm your Human Resources Partner. I'd like to welcome you to the Employment Law lesson. The most important takeaway from today's lesson is that Human Resources is your partner and resource. You are not expected to be an expert in employment law, but you do need to understand the fundamentals of employment law to keep the organization and you personally from risk. We will be covering several areas of employment law today. We will cover the following laws: Equal Opportunity Employment, or EEO, Sexual Harassment, Pregnancy Disability Act, or PDA, Americans with Disability Act, or ADA, Family Medical Leave Act, or FMLA, OSHA and Workers' Comp, Fair Labor Standards Act, or FLSA, Immigration Reform and Control Act, or IRCA, and retaliation. This is a very important lesson. As a manager, there are certain topics that you can be held personally liable for in a claim. We educate you on the employment laws to protect the organization, the employees, and you personally. Executives, supervisors, and human resource employees have been held personally liable in cases involving failure to pay wages or overtime, failure to allow unpaid leave, failure to make pension contributions, wrongful termination, wrongful hiring, infliction of emotional distress, defamation, failure to deposit withholding taxes, and other theories as well. Let's start with equal employment opportunity. EEO can be impacted by the processes by which employers recruit, hire, place, evaluate, transfer, train, promote, compensate, monitor, lay off, and terminate employees. In other words, most employee-employer interactions. It is illegal for an employer to discriminate in any of the areas just described based on race, color, religion, sex, including pregnancy, national origin, age over 40, disability, and genetic information. It is important for you to remember to follow policies and practices that are job-related and necessary for business operation. To ensure there is no discrimination or a disproportionate effect, please follow the processes put in place. For this reason, all topics listed above must be processed through Human Resources. Sexual harassment. Harassment is the unwelcome sexual advances, requests for sexual favors, or any other conduct of a sexual nature. Harassment can be in the form of slurs, offensive or derogatory comments. Harassment can be visual or physical as well. The harasser can be the victim's supervisor, coworker, another supervisor, and even someone who's not an employee, like a customer or vendor. Harassment can even happen outside the workplace, such as social media. Harassment becomes unlawful under two conditions. 1. Enduring the offensive conduct becomes a condition of continued employment. 2. The conduct is severe or pervasive enough to create a work environment that a reasonable person would consider intimidating, hostile, or abusive. It is important to note that all supervisors will go through a mandatory sexual harassment training within the first 90 days of employment and every 2 years thereafter. Pregnancy Disability Act. Employers cannot discriminate based on pregnancy, childbirth, or related medical conditions. This includes applicants and hiring decisions. Employers cannot force an employee to take a leave of absence simply because she is pregnant. ADA. ADA prohibits employers from discriminating against qualified individuals with disabilities in the job application process, hiring, firing, advancement, compensation, job training, and other forms and conditions, and privileges of employment. An individual with a disability is someone with a physical or mental impairment that substantially limits one or more major life activity or activities, or a person has a record of such impairment, or the person is regarded as having such an impairment. A qualified individual or applicant with a disability is an individual who can, with or without reasonable accommodation, perform the essential functions of the job in question. You may not ask an employee about a disability. You can ask if they are able to perform the duties of the job with or without an accommodation. If an employee requests an accommodation, refer them to Human Resources. Do not ask about their condition. ADA does not cover illegal use of drugs or alcohol abuse. Employers are able to hold illegal drug users and alcoholics to the same performance standards as other employees. Reasonable accommodation. An employer is required to make a reasonable accommodation to the employee or applicant as long as it does not impose an undue hardship on the operation of the business. This is based on the employer's size, resources, and nature of its operation. A reasonable accommodation consists of making an existing facility used by employees readily accessible and usable by the person with a disability, or job restructuring, modifying work schedules, reassignment to a vacant position, or acquiring or modifying equipment or devices, adjusting or modifying exams, training materials, or policies, and providing qualified readers or interpreters. An employer is not required to lower quality or production standards to make an accommodation. FMLA. FMLA entitles all eligible employees to receive unpaid leave for up to 12 weeks per year for family and medical emergencies relating to self, spouse, parents, and children. To be eligible for FMLA, an employee has to have worked 1,250 hours during the last year. Employers are required to place the employee in the same or equivalent job with the same pay, benefits, and conditions of employment. An employee who is a spouse, son, daughter, parent, or next of kin is allotted 26 weeks of leave per 12-month period to care for a wounded member of the armed forces. OSHA. The Federal Occupational Safety and Health Act, also called OSHA, requires employers to provide a safe working environment for employees. You must report fatal accidents to OSHA within 8 hours of their occurrence. You must post an OSHA poster informing workers of their rights and obligations under the law. You must also keep records of your efforts to comply with the law and to prevent injuries and illness. You must follow OSHA's rules for every worker in the business, regardless of the worker's title, status, or classification. OSHA requires covered employers to maintain a workplace that is free of hazards that they know or should know about, and that are causing or likely to cause death or serious physical injury. These are called recognized hazards. OSHA requires you to provide tools and equipment that are in safe working condition. It also requires you to adequately train and supervise employees, and it requires you to provide specific safety equipment when necessary. If an employee is injured, refer them to Employee Health Services immediately. FLSA, Fair Labor Standards Act, requires employers to pay employees who are non-exempt from overtime at least the federal minimum wage. Employers are also required to provide overtime pay of 1.5 times the non-exempt employee's regular rate of pay. An employer must pay non-exempt employees time and a half for work over 40 hours. Non-exempt employees must be paid for all hours worked, even if the hours were not approved. Be sure to approve the employee's time card and make sure it is accurate before you approve it, as it is a legal document. The Immigration Reform and Control Act is a federal law that regulates the employment of foreign workers. It designates which workers it is legal to hire and tells employers how to verify the legality of workers. It also prohibits discrimination against job applicants and employees based on national origin or citizenship. It is illegal for any employer to knowingly hire or employ foreign workers who are not authorized to work in the U.S. Employers are required to verify that every new employee is authorized to work in the U.S. using the I-9 form. Retaliation. Retaliation occurs when an employer punishes an employee for engaging in legally protected activity. Retaliation can include any negative job action, such as demotion, discipline, firing, salary reduction, or job or shift reassignment. Federal law protects employees from retaliation when employees complain, either internally or to an outside agency like the EEOC, about workplace discrimination or harassment. That's true even if the claim turns out to be unfounded, as long as it was made in good faith. The law also protects employees who cooperate in EEOC investigations or serve as witnesses in EEOC investigations or litigation. Employees are also protected if they participate in an internal investigation. Employees' complaints about unsafe working conditions are also protected. This concludes our employment law lesson. Thank you for your time and attention to this important matter. Please utilize human resources for your inquiries. Our goal is to work with you proactively to prevent risks to you and to the organization and ensure we're doing the right thing for our employees. Thank you.